Can you hear us now? Yes. Okay. So this was the functional equivalent of a practical joke at the beginning of my presentation. I did not find it funny. I hope somebody on the other side did. So welcome, welcome everyone. Thank you for spending your time with me. Thank you very much to Carolina for all the work that she has put in order to make this event happen. So the consumer welfare hypothesis in law and economics, which has a subtitle that speaks to a specific group of academics. And please tell me, you can also write it in the chat, because this is how things work now in the 21st century, if you know the answer to that question. So what is this book about? This book is about a belief that we all hold, whether we like it or not. I believe that many people have engaged with this idea. And the idea is namely that the market is a means to maximize total welfare. And some people like it, other people do not like it. We oftentimes derive implications for the legal categories that we have on the basis of this idea. But in my research, I have challenged, as a matter of economic theory, the accuracy of this assumption, not in the sense that this assumption is not widely held, so that if you make a bibliographic research, you will find many people supporting this claim, but in the humbler sense that if you make a careful research, you will find also people that matter for the economic analysis of law who support a different idea. And this different idea is that one market, for example, let's say the market for computers, is efficient when the welfare of the consumers operating on that market is maximized. So not the joint welfare of the producers of computers and the buyers of computers, but only the welfare of the consumers. And then what I asked myself was, okay, so I am a lawyer. I cannot tell to economists what is the best notion of allocative efficiency that they should use for their own purposes. But what I can perhaps investigate is which version of allocative efficiency is more in line with the way in which lawyers reason. Because if we can identify one concept of efficiency as more in line with the way in which we reason, it becomes easier for lawyers and economists to discuss with each other, even when they disagree, because it becomes easier to understand what are the deeper implications of what we are saying. So this is how the efficiency hypothesis that I worked with, the consumer welfare hypothesis, it was born. And then I was lucky enough to be able to find in the legal materials that I have analyzed that there is a clear answer to this question. The clear answer to this question is that the institutions that I have studied, in particular EU antitrust and EU consumer law, clearly make more sense, but clearly make more sense if you look at them in terms of maximizing consumer welfare rather than maximizing total welfare. And I will explain to you in a few minutes some ideas about this, how I did this. As a motion of order, I will try to be as brief as possible. And I have a lot of backup slides that we can use to discuss more in details several bits and pieces. But I would also expect that Hans is going to highlight many interesting ideas that will deserve our attention. So just to begin with some clarifications, I am not defending a hands-off approach. The idea is not that the market is efficient and derives the outcomes that we would want. I am simply saying that if we look at business to consumers, understood in broad terms, we can justify evaluating their performance, their effectiveness, okay, especially consumer lawyers, their effectiveness by their ability to increase or not increase consumer welfare. I also do not claim that we should turn everybody else into a sort of slave, or that nothing else instead of consumer welfare matters. I am adopting, and here I would like to thank Hanoch Dagan for having drawn my attention to this distinction, a distinction between internal values to an institution and external values to an institution. My claim is that the internal value for antitrust and consumer law is the maximization of consumer welfare, which may mean that sometimes these objective that has to do with the relationship between the conflict between consumers and producers on a certain market clashes with other social values like living wages for workers, or other values like the protection of the environment. And I'm not claiming that consumer welfare should always win. I am claiming that there are different legal techniques that we use when this kind of conflicts exist in comparison to the ones that we normally use when we are adjudicating cases where these external values do not come into play. And the last point, these are still voluntary agreements, okay? These are still agreements where both parties decide to enter into. The only point is that when this happens, we design them in such a way that the value created by the agreement flows in a certain direction rather than being neutral or hoping that it flows in another direction. But the consent has to be not an empirical consent. It has to be the normatively rich consent that we as lawyers, especially contract lawyers, would want contracts to rely upon. Now, so let me. It is really an honor today to have Guido Calabresi here, because the methodological intuition behind this project is something that I derived entirely from his work. And it is the idea that we as lawyers can contribute to the discipline of law and economics in terms that are more equal with economists. And the way in which I decided to, and this is why I decided to identify that identifying an ambiguity in economic theory and showing how legal reasoning could help solving that ambiguity is my way to do what he has recommended us to do. At the same time, I am well aware that we also need to make these palatable to economists. So after having worked and reflected upon this based on Professor Calabresi's work, I stumbled upon this concept, the legal economic nexus, from an institutional economist that is revered among institutional economists, who is called Warren Samuels. And he speaks of this idea of the legal economic nexus. He spoke about this already in the 80s, and it seems something that speaks very closely to all of those like me, who believe that the legal institutions and economic processes, they coexist and they mutually influence each other and they mutually create each other. And on this point, Professor Deakin, when he was sitting there and he was examining me, asked me a question, and I think I gave a very bold answer to that question, but we can talk about that later. So the idea that, and in honoring the path that Professor Calabresi and Warren Samuels have given us in the past, I call this idea that you can read in white, I call it the Samuels-Calabresi theorem. Then we can, of course, discuss whether this is really a theorem, and probably it is not. However, we all know that this expression has a certain currency and a certain clickbaiting, let's say, ability in this literature. So that's why I decided to call it as such. And I defended this thesis in 2018, and then COVID and life happened for a while, and I've been reflecting on the best way to package my research. And then what happened in the meantime was law and political economy. So this new movement of this new scholarship that tries to reject something, we have seen something similar also in Europe, but explicitly wants to use economics, but not law and economics, and especially not efficiency. And my proposal is that essentially, if the consumer welfare hypothesis is true, when we start taking it seriously and we build on it, we can bring back a distributive concern into our analytical framework. And this is an analytical framework that is narrow in scope, and it allows us the kind of malleability that law and political economy scholars complain law and economics has not had. At the same time, law and economics scholars can keep are reassured that efficiency is not rejected like law and political economy scholars are suggesting. So in a way, I would say it's a kind of a compromise that irritates everybody, but just as mildly. So perhaps we can, is a compromise everyone can live with. From a methodological point of view, and the first point is the one that perhaps it makes more sense to discuss with this crowd. We have been told, and especially if you do competition, you see this a lot, especially in these terms, that efficiency clashes with fairness or with equality or concepts like that. And this is also what I have been socialized into. But then one very interesting finding when I wrote chapter 2 of the book was that when you dig for the reasons that economists give for being concerned only about total welfare, they give you an equality norm. The equality norm that they give you is that we, as a legal system, do not have a reason to prefer the consumer to the producer, so we need to treat them equally. And if we treat them equally, the only reason that we have to prefer competition to monopoly is that the size of the pie is larger. So this is an equality norm, okay? So my move was to realize that there is an equality norm that is as sophisticated, is not, if not, in my opinion, perhaps a little bit more sophisticated in support of the consumer welfare standard. And this equality norm says that when I operate as a consumer, I am entitled to a certain treatment. And when I operate as a producer, you interacting with me are entitled to a certain treatment. So we are treating each other equally because we accept that we have this institutional division of labor, that we play these different roles in different contexts. And I think this is an idea that is quite interesting on its own terms. Now, I am happy to develop a little bit more on the other main implications, but perhaps this is the one that makes more sense to highlight first. I would like to say one thing. The last two things really before giving the floor to Hans are first, the question that we all receive when we are writing our thesis: who is our main audience? And let me tell you, especially if you do interdisciplinary work, your main audience, the main audience questions really sucks. It's a really difficult question. I mean, if you do economic analysis of law, it's easy in a way, but if you try to do law and economics, who is your crowd? Who are you trying to enlist in your project? Now, I would say that I would like to enlist in my project both people who do traditional economic analysis of law, people who do law and political economy. But it seems to me that on the basis of who has joined us today, this call is not being very successful. So let me tell you that the main audience at this point, if they do not want to change the way in which they're doing things, because there are path dependency reasons that may explain that, we can do without. And I think I invite especially the consumer lawyers to read a beautiful, beautiful book, which is not perfect, but it's still beautiful. And I hope you will be as kind with mine later, okay? You can be beautiful while being perfect. Let's establish this premise. Consumer Theories of Harm by Riefa, Siciliani, and Gamper. They are a lawyer, a doctrinal lawyer, a consumer activist, and an economist. They sit together and they wrote a beautiful book about ways of using standard economics to identify problems in real consumer markets. And perhaps this is the way forward. Perhaps the way forward is not trying to involve people who do law and political economy or economic analysis of law. Perhaps the way forward is reaching out to your colleagues at the economics department. I think there are reasons that would justify this claim, and we can discuss this further. Of course, I would want everybody in the most ecumenic sense to be on board, but at the end of the day, we do not need somebody who self-identifies as a specialist on this interdisciplinary work to do interdisciplinary work, because we can do it as a collaborative activity. And with regard to the main audience, of course, there is a chapter on antitrust law, there is a chapter on consumer law. I think personally and I would like to hear what the contract law theorists who are in the audience think about this. I think that they are the group that can find something most interesting here, namely that there is a new kids on the block. So there is a standpoint that needs to be analyzed as for its normative properties that I tried not to focus on because I wanted to do a positive project. And we can reflect on how this idea connects to, for example, Hans' idea of access justice. We can reflect on how it connects with the normative theories that Martin has surveyed in his book. We can see whether in Dagestan, if I remember correctly, that was the name. In Dagestan, we would want consumer sovereignty as one of our main normative principles. And since it is a positive, claim, positive claims have to be evaluated also for their expansion potential. And I think that I have focused on a very narrow set of legal materials, and the one natural thing to do is to expand the scope by looking at those areas of law that are connected to antitrust and to consumer law, but are not strictly antitrust or consumer law, and to expand it. I have already started working with some experts in trademark and copyright, which are IP-related stuff, on how to expand this. And then, of course, an idea that is very intriguing, I think, is there is a whole branch of law and economics, which is called comparative law and economics, and we could hopefully see how that goes from that point of view. I will stop at this point, leaving this simplified structure of the book as a background. So as you can see, part one makes the case for why allocative efficiency is an ambiguous expression in economics. And then the second part sets to test which one of the two versions of the concept has a better fit with the content of legal reasoning in EU antitrust and consumer law.
Switch it off, please. Great. Thank you very much, Fabrizio. Now, Hans, the floor is yours. And then I think the discussion will be very rich because Fabrizio hinted at various people in the audience whose comments I think would be very interesting to hear. Please, Hans, go ahead.
Yeah, thank you for the occasion. Thank you for also making me read again the whole book, which was really fun. Let me start with a personal note, as there are so many people sitting here in the audience. When Fabrizio came to the EUI, we were working together, and I have to admit with pleasure that I learned a lot from him about law and economics and behavioral economics that in the end led to a contribution which I think he doesn't really like, or at least partly like, what I call the politics of behavioral economics of law, which is a little bit what I'm doing here. I'm looking outside in. I do not feel myself as a law and economics lawyer in whatever language, but I'm trying to understand, and I think it's crucial to understand. So Fabrizio, you wrote really a very nice, easy to read, accessible book, short, which is also, I think, helpful when you are asked to comment a book and you just have to read 200 pages. That's a pleasure, you know. And you also start with this wonderful poem from Bertolt Brecht, to which certainly we should come back at some point. So let me start with how I read the book, what the message of the book is. And the major message for me is that the intellectual history of economic and legal thought has to be rewritten. It has been distorted in a particular way. You leave it open why that has been distorted and what were the drivers behind, which would be a story in itself, how this particular interpretation of the intellectual heroes that you are working on have been twisted into a particular direction. So that's the first point. The second message is allocative efficiency is not about total welfare, but it is about consumer welfare. And you explained in your introductory remark, although there is certainly much more to say what consumer welfareism is all about and what it does and what it cannot do, but that is certainly a point to discuss. You also offer a method, your own method. You call it reverse engineering legal reasoning, which according to the book provides the tools which allow you to legitimately classify whether a certain piece of law aims or does not aim at total welfare or consumer welfare. And last but not least, you apply it to competition and consumer law, EU competition and consumer law, and your argument is based on the methodology and based on the rewritten intellectual history that EU law is mainly about consumer welfareism. And that is also directed against many EU lawyers who understand in particular consumer law as just being an instrument to realize and complement the internal market, whereas you show, and that is your major point in the detailed analysis of the chapter, that this is misleading, or it's not the full story. So that's the message of the book. It is based on a number of premises. I will distinguish between the explicit and the implicit ones. So explicit, and you also said it yourself, the book is written from within. I call it from within. So you take the perspective from inside the whole debate on law and economics, how it developed, in what shades it develops. And the purpose is, so to say, to use a metaphor here, you want to beat the protagonists with their own weapons via applying their thinking and their methodology. You want to show that not only the intellectual history, but also the way it is applied is problematic. To be fair, and that is the poem, it is your interpretation, that's what you repeatedly say, and you don't claim that this is the only interpretation or that is the only correct interpretation. It is, however, this inside perspective has quite an important consequence. So we can talk a lot about effects and effectiveness, which brings us to methodology, and which, in my understanding, is also in a way the distinction between economics and sociology, which is totally outside the picture. But that is due in a way to the very legitimate decision to argue and to build your argument from within. The second premise is the Samuels-Calabresi theorem, as you call it. That means the interdependence of law and economics, and law and economics. I think that is, in fact, for me, in my understanding, in the theoretical world in which I am living and where I feel comfortable, that is very closely connected to Polanyi and to his kind of thinking of how law and economics interact. And the third premise, and that is also, I think, a crucial one, in particular, what you want to do next. It is the claim in the very beginning, a strong claim that ideas are changing the world. That is part of the way you construct and you criticize the intellectual history which stands behind this economic thought. In that sense, it's a very French book. It's French philosophers, French legal thinking. Think of the story of the Code Civil, which has been marketed as a democratic project, although that is simply wrong, historically wrong, but nevertheless successfully promoted. But that means also, if we change the narrative, if we reconstruct the intellectual history properly and apply the proper method, then we pave the way for consumer welfarism. And then there are three implicit or more implicit premises. Which is, as you say in the end, again, to be fair, which is something what you want to study further, but you link the maximization of consumer welfare to fairness. So there is this implicit suggestion that welfare is connected, consumer welfare is connected to fairness. Although the linkage between two is not really developed, between efficiency and fairness. The other one, equally implicit, and maybe as Martijn is here, I'm sure he will raise that point. There is some undertone, so to say, that this consumer welfarism is more democratic. There is an element here in the beginning that, where you suggest that this understanding that you derive from your Samuels-Calabresi theory connected to consumer welfarism is more democratic. And last but not least, that consumer welfarism that is in a way connected is also in a position to produce a better society or a more solidaric or whatever. That is also implicit. I see it as an undertone in your work, but it's not really developed. So what are my critical points? I will not, perhaps contrary to what you seem to suggest in the beginning, Fabrizio, I will not go into details here. I think categories and categorizations are always debatable. Yeah. So for instance, I'm not so happy with your distinction between empowerment and protection. First of all, I don't like the word empowerment because it has a particular intellectual history, which is connected to to the rise of all this language of neoliberalism. But be that as it may, I think it is really not important because it doesn't go to the core of your argument. So my first point is, when you talk about the history of economic thought, what I'm totally missing in your reconstruction of the intellectual history is the 1920s, is the whole story about ordoliberalism, and it's in particular the discourse about democratic economic constitution, which was a big issue in the 1920s in Austria, also between Kelsen and the Austrian economists. So that's my first point, where I think, where I have some problems, so to say, with this American bias. And the other is on the methodology. I understand that in order to really stay within your rationale, that you want to beat the protagonists with their own weapons, that you use a particular methodology that has been built in the American context. But then the question remains, to what extent it is possible to use this American economic and legal thought and the American legal methodology, to adjust it, and then to apply it into a European context. There is a transfer here where you jump over a bridge, which to my mind is not so easily to cross. It has implications. In an innocent perspective, one would have expected that you now start criticizing American competition law and American consumer law. But no, your topic is EU competition and EU consumer law. I will not criticize why you have chosen competition and consumer law. I think you try to rationalize this with convincing, sometimes debatable arguments, but that is a choice which is always subject to critique. So I will not comment on this. It makes sense, as in particular when you talk about consumer welfarism, that you deal with consumer law, although in a way the choice of the two might a bit weaken your argument, because when you analyze EU consumer law, I think nobody will really be surprised that the major or dominant paradigm is the promotion of consumer welfarism. But that might be also a sidestep. My third point is on what I said on this undertone, on the undertone that consumer welfarism is more democratic. Here I would like to ask you a question. Could consumer welfarism also be realized by a totalitarian regime? We know that in China we have a very highly developed consumerism. We have this wonderful book from Frank Trentman, where he also shows exactly how consumer law is a substitute for political participation. And here I would like to see more. I think you know the PhD from Elias Deutscher, who argues that the competition law in the United States has democratic origins. And he also transfers this argument to the European context. Although, to my mind here, he also is quite fast. He's currently transforming his PhD into a book, so we will see what it whether it can be developed. In short, so one of the key points here for me is this link between consumer welfarism, competition law, consumer law as the point of analysis, and democracy. And last but not least, but this is really my last comment, I think that the debate in legal theory is currently moving a little bit also into a different direction. I don't want to praise here the book that Stefan and Moritz have written, because we are arguing for an pluralist approach. But there are also other tendencies in legal theory claiming, let's say, the law as a self-standing discipline and seeking the Eigenrationalität, that's the German word, so that the law is in itself able to produce rationality and the values that it needs, and that this interdisciplinarity is of limited value. So this is just, let's say, to add that to my mind, we have a divide here in legal theory that demonstrates also new food for thought. I leave it like this. Thank you very much again for the occasion and for reading the book. Thanks, Fabrizio.
Thank you very much, Hans, for your comments. If Fabrizio agrees, I noted that Professor Calabresi raised his hand, so I think you do agree. So please, Professor Calabresi.
Just one small comment. First, a wonderful book, a start for much conversation. One way of potentially connecting consumer welfarism with total welfare is if one goes to a point that Coase actually made in his theory of the firm, which was that it may be that command is not less costly, but that people like command, or that markets are not less costly, but that people like markets. That you can't, as I've said later, understand Van Hayek without saying that he liked the market, and so even if it brought general welfare at a considerable cost, he would still like it. And the same true of Trotsky in terms of getting general welfare, in terms of command. Now, if it is the case that people like consumer welfare, that we have in our utility function a desire for consumer welfare, then if that desire were worked into the market, worked into a whole welfare system, it would mean that consumer welfare would also be general welfare. Economists never think that way. But it's odd, because in other contexts, of course, we do think that way. We don't think that caviar is an inefficient way of feeding because it costs more. We like it. And so with many things, so that if we were to take into account the degree to which what you call fairness or consumer welfare is something we like and are willing to pay something for it, that is, if economists were true to their word that tastes are taken as given, then that taste should be paid heed to and would connect the two things. I don't know that it works that way, but it is just a thought brought on by your wonderful work. Thank you.
Thanks a lot. Fabrizio, I think you want to briefly reply to Professor Sminkli's comments.
Yes.
Please.
So thank you, Karina, for reading my mind so careful, so precisely. And so Hans, Thank you. Thank you very much for your comments. They are also super well structured, so it's also very easy to engage with them. So on the point on ordoliberalism, yes, there is an American bias in this book. It is also contingently the case that I am trying to show that on the terms in which this debate has developed, which is mostly as an American-powered way of thinking, the economists that I am taking into consideration matters for that debate. They are not only Americans. There is a Hungarian, there is an Italian. Many of them were based in the UK. 3 of them were also Austrian, and I have taken them, sorry, 2 of them is Austrian, one is an Austrian from Alabama, which is a bit confusing, I think. And I took them into consideration because they matter for that literature, but I completely take your point that the liberal side of the story could contribute to a deeper reflection. I would like to call upon the work of my supervisor, who is in the audience, who has worked on this matter. And I think that the direction that he has given to his reading of the older liberals might not go directly, specifically in favor of these of the idea that I am relying upon, but it goes in a direction that is workable with. However, and this I think is the more methodological remark on this matter. Today I gave a presentation at the University of Pisa, and I would like to thank Valentina Calderai, who is here for making that possible, and Nicola Giocoli, who is a very, very nice economist and a very keen specialist in the history of economic thought. He has pointed out to many additional things that I could have written better, things that I have not taken into consideration, things that would have strengthened the argument. But at the end of the day, this is, I think my point is that this is not, I'm not an historian of economic thought. I had a Lutheran approach to this. So I took these sources that they mattered for the law in economics, the economic analysis of law movement, and I set by myself to try to search in them what matters for my research hypothesis, which is very different from the rich historical contextualization that historians of economic thought can bring. But if it is true that there is, as Hans mentioned, and I try to be less ambitious, there is a need to rewrite the intellectual history of economic thought. That is a work for the historians. So maybe we should go up and ask your colleagues to help with that. With regard to the American context and not criticizing the Americans, looking at what is happening in US law, I have to give a very similar defense. I am a European scholar. I am being socialized in our cultural environment, lucky enough to be at the European Union. And as Professor Sims I hope he would support the claim that it would have been a bit dangerous for me from here to analyze American law and to make claims about the content of American law, which develops and is argued for in a very different way. But I think that if there is a specialist, one of the things that I hope for, and it is one of the things that the subtitles of the book hopes to stimulate, is a replication of this kind of research by Americans who look at their own legal system with an adaptation perhaps of this framework, because, for example, they have dissenting opinions, the Court of Justice does not have dissenting opinions, so how do you factor that in the framework? Very complicated questions. And with regard to totalitarianism, I have 2 points here. First, the claim that I make about the authority of democratic institutions is contingent, and this is contingent to the fact that I believe that I am analyzing EU law, and that I believe that with all the flaws that the European Union may have, it deserves to be considered a democratic institution. So since I am making a positive claim that tries to describe an economic concept that fits with the practice of this authority, if this authority is a democratic one, it is under the authority of a democratic authority that we can claim that EU law fits with the idea that efficiency is about consumer welfare. So that is my connection with the idea of democracy. Now, I will not leave it at that, and I will take debate on the provocation about totalitarianism. And here, this calls into question something that I did not need, I feel that I did not need to engage with in the book, namely, what is the theory of value that we use to define consumer welfare? I felt that this was not necessary because at the core of my work, there was a conflict of the interest of consumers and producers and how and to what extent they were relevant and how they were relevant in the law. We do need for many, many reasons to start reflecting more carefully on what is the theory of value that we use when we talk about the welfare of consumers, the welfare of workers, and so on and so forth. And I have been reading already on these things because I'm not unaware that this is an interesting direction for future research. And my understanding of what a workable notion, what would be the constituents of a workable notion of welfare is that the lack of autonomy, the lack of feeling in control is probably very problematic from the point of view of what makes a life worth living. And I think that this is as far as I can go to in the direction that Hanok would want me to go, because I think he would want me to say that this is even more important than what I'm willing to say. And then on the last point, law as a self-standing machine, I think that honestly, in the 21st century, the burden of proof is on the people who support this claim. And I would want to see how they wish to regulate platforms, smart contracts, and all sorts of environmentally threatening things and potentially poisonous food, if we really take the stance that we can find the solution to these very difficult questions within the law as it is, without the need to the support of any other academic and scientific activity. So I think that the burden of proof is on them, not on us. And what Professor Calabresi pointed out, I think that of course there is a connection between consumer and total welfare. He is proposing the idea of injecting a preference for consumers in the social welfare function as a contingent element of the social welfare function, so that a different society may have social welfare function with very different content. This to some extent, I think it would work. I am currently reflecting on something else, and if you read the book, there are two lines of reasoning that you find in both in consumer law and in antitrust law. One is in Mostaza Claro, and the other one is in Tela Soneras Verige, where there is some vague connection between the idea that at the higher level, this really has to do with the well-being in the European Union, or the well-being of the European Union, or something like that, which somehow resembles the idea of total welfare. And then when you go on the particular institutional practice that is subject to adjudication, it is clearly consumer welfare. So there has to be somewhere a connection between maximizing consumer welfare in one single market and a society that is organized in terms of maximizing some version of total welfare. And if you read the work of Matthew Adler in particular on what is the possible content of a social welfare function, this does not mean at all to maximize the total welfare without any distributive concern. There is a lot of flexibility that you have there, but if you read carefully, if in the footnotes, let's put it that way, of the conclusions, there is a hint for the direction that I think we can go to try to solve this puzzle where we have one market that maximizes consumer welfare, but the market system that maximizes total welfare. And yeah, Karina, yeah.
No, I noticed that there are already some hands raised, so I'm very curious to see how the debate goes. So I think Professor Hesseling was first, but just by a few seconds, and then we will have Professor Dagan. So Martijn, please.
Thank you, Carolina. Thanks, Fabrizio, for the presentation and for your book. I must confess, and haven't yet had the chance to properly read it, so my comments may just come out of ignorance. I have 4 small points. The first one responds directly to Professor Gallavresi's point. What if people, the public, likes consumer welfare, but what if that particular liking is a form of what neo-Marxists would call adaptive preferences, right? That society is shaped in such a way that they are well, almost, it is difficult for them not to like consumer welfare. The second point goes a little bit in the same direction, or a bit further. Also, let's say Frankfurt School critique. I think that in a sense we already have, with the strong focus of consumer protection instead of sometimes sort of understood as a proxy for interpersonal or relational justice, we already going very much in the direction of further consumerism. Now, are you not, Fabrizio, adding insult to injury if we now are going to even centralize that consumer welfare even further in our understanding of what is actually going on? So are you not unduly understanding individuals as consumers? So essentially, it's a question also. What exactly do you mean by consumer welfare? When can we understand our welfare as welfare in the capacity of a consumer, right? Given that with privatization, so many relationships that we used to have with the state or otherwise have now become consumer relationships, do you then simply follow in a rather legal positivistic way, but also with certain important implications, the labeling of consumer for those relationships? And then the last point is really how you see then the contrast between consumer welfare and what the EU itself says, in particular the European legislator, which of course has these slogans of justice for growth, where consumer protection is presented as the aim of consumer protection, or at least one of the aims is presented even in terms at the time of overcoming the financial crisis, and we must use consumer protection in order to enhance overall growth. And I was wondering how you see that contrast. It's probably all in the book, the answer is already there, so I really apologize if that's the case.
Okay, I would actually collect a few questions and then let Fabrizio reply. So Professor Dagan, please.
Thank you. So first, Fabrizio, really congratulations. That's, as you know, I admire the work and I think very highly of it. But I'm going to be critical, as you would expect, especially that you wanted me to be the ambassador of Afghanistan. So, and you know, a term that Martijn coined, of course. So I think that there is a lot of, and I need to apologize. Kind of, I'm in between, in a sense, Hans and Martijn. As you know, I've read the book before it was a book, but I haven't reread it for today. So part of what I'm saying is from memory. So, and maybe I'm just mistaken. So I think you're making a lot of sense of the way the people on the ground that do the kind of work that you're interested in, be they lawyers, economists, are doing the work. So you're creating a coherent analytical framework that can allow us to understand what they're doing. And that is extremely valuable. And the point that I want to emphasize is my first point is kind of a continuation of Hans's point of them from within. So from within, it allows also people that are coming from the outside to see what's going on. And then when you're from within, you can take two different perspectives. So you can say, this is what is being done, and I'm either agnostic or critical about it. But sometimes anyone who does the work from within, myself included, may tend to get in love with the from within, and you also have a kind of the crusade of helping the economists and lawyers to communicate better, which is valuable. And I think that then you're trying to make a reconstruction, a kind of present it in its best light possible. And this is the moment I think that our paths to some extent diverge. And so I don't. So with Martin, I'm more skeptical of I think on 2 points, and maybe even the third one. So here are my 3 substantive points. So first point is about the significance of preferences, and for that matter, tastes as well. So these are, on my account, extremely instrumental values, and things literally go wrong when we treat them as ultimate values, because there is a gap between our ultimate values, and I won't, my shtick, so I won't take more time on what it is, but I don't think that preferences on any coherent view can be our ultimate values, because in order to make sense of the idea that they matter, and that my preferences, if they are as intense as yours, matter the same, we need something that is more fundamental than preferences themselves. So once we said that this is what's going on there, I think that we need to be somewhat critical of that, which brings me to the second point with respect to the significance of the preferences of the consumers, right? So if the preference of the consumers are proxy for what everyone wants, and say if we say that we are all both consumers and workers, and that is equivalent, maybe there is a wash, but I doubt it. And I also doubt that even if we are all consumers and workers, I think that our capacity as workers is more significant to our autonomy, for example, which means that overemphasizing consumer welfare by treating it as a proxy for aggregate welfare and treating that as the fundamental value may take us astray, which again does not mean that consumer welfare is not important, but I think that it means that it is important as a subset that needs to be put in its right place, and its right place, I think, is somewhat different than where you would put it. And the last point, if I have 2 more minutes, is regarding the relationship between law and economics. So I appreciate the desire to create communication. I think it is extremely important. I appreciate that the cross, but then I think that there are compromises there that are problematic. Again, I think that this is buying too much into the lingo of economics, and I think that our task as lawyers, if we agree that in the first point, the kind of the normative point, is to put the economic input in its proper place in the kind of whatever normative scheme that we have, rather than try to make them on equal footing. But yeah, and I'm sure that I didn't surprise you in any of those points.
Great, thank you very much. If there are other questions. Okay, can you hear me better now? We're mixing.
You're muted.
My fault.
I'm sorry. Yeah. Fabrizio and I are using two computers at the same time. It's not working well, as you can see. I wanted to see whether there were other questions either online or in the room. If there aren't, I would give Fabrizio some time to reply to these questions. No? Okay, then Fabrizio.
Yeah, a point that is common to what Martijn and what Hanoch have said. So first of all, thank you for the comments. And Hanoch, these are the nicest words that you have said to me ever, and they are on the record now. So that's a win for me. Yeah, so individuals as consumers and what consumer welfare means. One of the things that I think make powerful the analysis in the second part of the book is that the thesis works when you use the very narrow notion of a consumer that you have in consumer law, but also the very broad and flexible notion of the consumer that you have in antitrust law. So if I were to get, in my understanding, it is essentially, and that's why I think a principal agent framework is the one that best captures this idea, is you have somebody who delegates to somebody else the execution of a task on their behalf. So whenever I need a phone to make a phone call, and I buy or I loan or whatever else a phone from somebody, I am satisfying a preference by entering into possession, depending, or property of an object that I did not have. So, for example, one thing that this way of looking at things suggests is that perhaps the sale contract is not really the clearest case of a contract type that we should look at. Perhaps we should focus more on the service contract as the paradigm of a contractual relationship. And yes, with regard to the Justice for Growth slogan of 2012, that was perhaps not the most the brightest moment in the political communication of the European Commission. And however, it was also a political statement, and I have not identified any real impact of that political statement in the content of legal decision making. So perhaps it was something that was necessary in order to appease certain political actors that were particularly concerned about things that were being discussed in Brussels. So I'm not entirely sure that the Justice for Growth unhappy slogan left the place of political discussion, and really matters for us as legal scholars. Now, with regard to what Hanoch is saying and the fact that we are all consumers and we are all workers, I think that is, and the fact that, I mean, we are academics, so let's be honest, either we define what we do as something that we do as consumers, or the truth is that we work 12, 13, 14 hours per day. So it seems self-defeating on my behalf to focus on the protection of the consumer, whereas I am primarily a worker. And here the point is that one of the things that economists, when they build principal agent models, do not do very well is to define the participation conditions. They delegate the participation condition to the external context and what are the best offers that are out there. But we as lawyers, we can totally say that perhaps one of the things that needs to be included in principal agent models that are worth being implemented is that one of the constraints that the agents are entitled to rely upon is, for example, as you have been protesting in this institution very recently, living conditions for workers. That is one of the constraints that we can totally model into our principal agent framework. But I would stick to the claim that once we have identified the kind of constraints that we want our agents to be able to rely upon, which also include reward for their creativity, okay? So you can get rich as a creator, content creator, inventor, you name it. There are legal institutions that allow for that. And we're not denying that this is part of the framework. But bottom line is that this mechanism is a value creation mechanism where what is being created has to be valuable for the consumers. And then one very important question is to what extent we are willing, and I'm surprised that no one has really picked up on this specific point. Perhaps Hanok was talking about the preferences. We need a normative, at the end of the day, we need normative theories of what makes something valuable in order to be able to decide to what extent we should rely upon the decisions of individuals left to their own devices, to what extent we should, empower them to make them able to make decisions that are worth for themselves, and to what extent we need to protect them from the mistakes that they're going to make and from decisions that they simply do not have the ability to make, in the sense that the complexity of the alternatives or the opacity of the alternatives is overwhelming. So we need to create institutions that make those decisions for them. And then with regard to the last point, which Hanok made, namely, we perhaps need to figure out what is the proper place for the economic input. I agree, and I think that in a way that is the whole point. So if I am correct, if this hypothesis is true, one of the places where economic input is helpful is in order to better understand the hidden structure of the legal institutions that we have. And I would like to remind that if we historically look at the development of law and economics, and perhaps we can ask Guido Calabresi to confirm that this is an accurate understanding, what made Posner's research famous was the claim that there was a hidden logic in the common law system, and that you, law student, who receive cases thrown at your head every week, and you struggle to identify what is the logic behind all these cases, there is one book which is based on a limited set of tools, which is described in one chapter. And if you master that chapter very, very well, and you read the book, then you will understand what the hidden logic in all that conundrum of cases. So at the end of the day, it has always been the case that one of the things that economists have claimed for themselves, and one of the reasons why this discipline became successful, was the capacity of economic concept to explain something about how the law is structured. So I would think, and I do not know if the audience agrees, that this is one of the things that belongs to the place of the economist. And once that is identified, then we can have better discussions with them on how they can advise politicians and lawyers on what is the direction that the law needs to take for the new and controversial matters. For example, price personalization, which is a topic that when I was in Israel, I started getting a little bit obsessed with. And I would leave it at that, perhaps.
Yes. Okay, we do have a question in the room, if I'm correct. Matthias?
Camera's not moving. Ah, now it's moving. Yeah, Fabrizio, first of all, congratulations to the book. I have to admit, I haven't read it, so I'm looking forward to it. I saw it's also available electronically for everybody, so that's great. Therefore, first a question about something you mentioned for future research. And you may guess at the point about comparative law, but that would be a possible extension, because it seems a bit a different level, because you talk about different areas of law, but how comparative law? There's obviously discussion about comparative law and economics. So there I'm not asking you to disclose anything you're working on at the moment and that you want to keep confidential, but I'm curious. And my second question is, what about experimental or more general empirical work? At the moment, obviously, you talk about your proposal from a normative theoretical perspective. Could there be something empirically testable? I don't know, what's best for society? I'm mainly thinking because law and economics has also moved in the empirical direction over the last 50 years. And that's, I don't know, perhaps also could be a further line of perhaps research, possibly, unless you tell me one shouldn't deduce an ought from an is. So that's obviously also correct, but.
So thank you. Shall I
No, please.
Okay. So on the one hand, there is this branch of law and economics that's called comparative law and economics, and the efficiency hypothesis that they test is the total welfare one, and then they derive critiques of institutions, and then they say, oh, the American approach to remedies in contracts is better than the German approach. That is very contestable on its own terms, because, for example, I think that the Italian approach is better, and I've not been convinced by the arguments that this is not the case. So there is a lack of rigor, I think, in at least the works that I am familiar with, but I do not claim to be a specialist in that area. But one thing that I am curious is to see if those claims hold true if you change the efficiency hypothesis. So this is the more of a low-hanging fruit. And then something that maybe you would call foreign law studies, rather from, at least from my perspective, is to see what are the difference would be to test the same hypothesis on US legal materials, selected according to criteria that are convincing for US legal scholars, and adapting the framework where that is necessary, taking, for example, into consideration the very significant difference in the relationship between labor law and antitrust law in Europe and in the US, which makes a lot of difference from many perspectives. Experimental work, there are different things that we could test. One thing that we could test is the intuition of, to what extent this intuition of we could turn these hypotheses into intuitions that, for example, we test through vignettes. So we expose people to different scenarios and we ask them which one makes more sense to them. One thing that could be analyzed also from this perspective, which is a bit more complicated, I would believe, is once we have an hypothesis of what could be a plausible mechanism that explains why we would want an economy that maximizes a social welfare function, which one, it doesn't really matter for this purpose, but at the same time, we would want a standard for each individual market that maximizes consumer welfare. So we could, I think there is I am working on I have an intuition for mechanisms for that, and that could also be tested empirically. And you made a third point, but I admit that Carolina distracted me, so it's her fault. Okay, so then. So I hope that was satisfactory. But if you know, for example, somebody who would like to work on these topics, please send them to me.
Okay, we do have a question in the chat from Gabriel Uscamaita, and he's asking, in the part devoted to reverse engineering legal reasoning, where you refer to method created by Damiano Canale and Giovanni Tuzze, there is something like a reference to the fact that the classical dominant hypotheses were dominant because these had no competing hypothesis. Would you think that much of the gaps in the previous approach occurred more because there were no sufficiently strong competing hypotheses than because of lack of advances in the discipline? What a question.
So thank you, Gabriel. I do not know. The honest answer is that I do not know. My understanding of what was happening is that this was a narrative that was not challenged. So okay, so this is, I think, is a better answer. I do not know the answer to your question, but I think your question points to a flaw in the way in which the opposing literature engaged with the economic analysis of law, which is it failed to engage on its own terms, because you may say that it was not the task of Posner and his co-authors to compare. I think it was, but perhaps it would be also acceptable to say, I am testing this hypothesis. It is for somebody else to come up with an alternative hypothesis and to test in similar terms. So perhaps one of the reasons why that literature grew so uncontrolled is that because it was criticized by many people, but not really on its own terms. And I think I will need to think more to what you asked me, Gabriel.
Great. I do not see other questions online. Gabriel is thanking you. Do we have questions in the room? Oh, okay. We do have a hand raised by Martijn. Please, Martijn.
There's no one else in the room because they go first, of course. Okay. Now I still wanted to perhaps ask for some more patience with my ignorance of the content of the book. So are you, Fabrizio, now positing consumers as a social group, or do you understand that a capacity in which we as human beings may act? And in the latter case, are you then proposing some sort of proxy for determining what we as human beings want in our capacities as consumers, what would make us better off in our capacity as consumers, so what would make our lives go better, or what would have more preference, satisfaction in our capacity of consumers? Do you don't have a proxy, or do you, is your claim really that what matters is our actual, that it's important, the normative claim would then be that it's important that we are better off as human beings in our capacity as consumers. If it's a proxy, then the question becomes, I would suppose, let's say lower prices or a wide variety of products to choose from, or both. If you use that proxy, how strong is the link then between what you claim to be the aim, consumer welfare, as something important, and these specific proxies? Or is it simply that? Is your claim then we should somehow we are better off in a society, we are a more happy society, or our society is better when consumer prices are lower?
So thank you, Martijn. So ceteris paribus, lower prices are better. I would say that this is a starting point that we can reflect. We can tentatively keep. The problem is what is it in the ceteris paribus? This is always the question with ceteris paribus claims. So what are we willing to sacrifice as a society in order to have lower prices? And there are certain things that I am not willing to sacrifice, and I think we should not be willing to sacrifice those things. However, I have to, in my understanding, when I speak about consumers, I am speaking about a role that each individual plays sometimes when he is operating in society. So sometimes I am a professor, sometimes I am a father, sometimes I am a husband, and so on and so forth. Sometimes I am a consumer. And what I'm trying to describe is the framework, the institutional frameworks that regulates my relations in my role as consumer with other people that contingently are operating our producers when they choose to interact with me. I'm not claiming that this is a comprehensive picture of the institutions that we need, but it seems to me that it is the case that antitrust and consumer law are two core institution, are two pillars of the internal market that we have. And so it is interesting that they have, if it is true, and you will have to read the book in order to ultimately decide if that is convincing, that it is the interest of the people who are acting in their capacity as consumers that is the lighthouse that guides the normative concerns that animate the institutional, the rules that we have to govern those interactions. I don't know if it is good enough, but really it is all I have, Martin, at this point.
Thanks, Fabrizio.
I see that Professor Dagan wants to add something to this. Please go ahead.
So I think it's just a follow-up on Martin's point, maybe. It's here's the risk that, as I see it, in our capacity as consumers, we are, as you rightly answered, Fabrizio, we use a currency which is easily manipulable in the equations of economics and so on and so forth. And whereas in our other capacities, we don't, right? And then the question is, where do we pigeonhole the optimal arrangement that we have in the former capacity to that overall picture in which we engage in relationship also as parents, as neighbors, as workers, as citizens, and so on and so forth. And so what I was trying to push, and I think that Martin in another kind of set of concerns is pushing in a similar direction, is whether the bridge that you are building doesn't involve also almost an intrinsic hazard of allowing the kind of an overextension of the significance of the consumer capacity vis-a-vis other capacities in which we engage. I think that's the concern. And again, it's an external concern to some extent. So because you can carve it in a way, but some of the way to present your project seems to say the opposite, seems to say that you are actually interested in expanding it. And that is, I think, where the alarms of at least the two of us, I think, are raised.
Fabrizio, yes, please.
So, Hanoch, I did not hear entirely the last part of what you said, but one thing that I think is at least the beginning of a proper answer to your comment is that the fact then when we are entering into exchange contracts, because this is my understanding of what this framework is about, there are certain rules of the game that are animated by certain values, does not really tell us much about what are the rules of the game and the animating principles when we are acting with others in our role as neighbors or as family members or members of a team or of an orchestra. I do not know if some of you are playing in the chorus here. I do not think that the consumer welfare hypothesis has much to say about your role in the chorus. There are probably other sources of norm or of inspiration that we need to search for. So my claim is that this is a narrow, okay, this is a narrow theory. It's a theory about a certain type of relationship. The fact that this is one of the types of relationship in society is true, but I do not think that it is problematic for the theory, because as this is not designed to be a theory of everything. So yeah.
I think this is a very interesting note on which we can conclude the event. Fabrizio, thank you very much for being with us today. It's always a pleasure to have a UI alumnus here And also, I guess it's nice for you to see that private law is still very much alive at the UI. We are not many researchers here, and my colleagues always hear of me complaining about this, but then we organize this event and we have people from all over the world attending, which is a great pleasure. Just one last thing I wanted to say is, if you'd like to be updated on the events of the private law working group, please do write your name in the chat. I will write them down and I will add you to our mailing list. We have a few other events lined up for this academic year, and we would love to have you with us to have this vibrant conversations. I do have some comments myself on Fabrizio's book, but here in Villa Salviati, now we have drinks, and I think I can bother him while he is sipping Prosecco. I don't think he will appreciate it, but it's like this. Thank you very much for being with us.
Thank you. Thank you. Bye-bye.
Thank you, Fabrizio. Wonderful. Thank you.
Congratulations again. Great book.
Thank you, Fabrizio. Thanks a lot.
Grazie a tutti. Thank you.
Okay. Okay, so maybe Elena, I'm gonna write down these names.
Yeah.
But we have the two other coordinators who can start like taking you downstairs. Okay, grazie mille.